Yo, 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 yo! What it is, people, we is back. Another day on Keep It G News. And they are in Atlanta, Georgia. Ysl Fulton County Court. We ain't been there in a minute. I told y'all I was staying away from it because I told y'all I don't really like what's going on with Young Thug right now. Y'all, I think the case, to be honest, in my opinion, is a shit show. If I was a resident of Atlanta, Georgia, I would be highly upset that this is where my tax dollars is going. Out of all the places it can go, you got a homeless problem down there. You got a lot going on in Atlanta. But this is where they choose to spend their money on. Let me explain why I feel that way later on in this video. But what y'all gonna listen to in this video, what y'all gonna watch is this 911 tape that y'all probably already heard before. But I'm also gonna let y'all hear the argument that led up to this 911 tape, because it's important. You understand what I'm saying? So, before I let y'all listen to the argument, I want y'all to listen to the tape first.
It's not an emergency. The guy that shot the guy over here off Cleveland Avenue, he's in my friend's apartment, and she's panicking. She don't know what to do.
Okay, what's going on?
There's a guy, I guess somebody must have shot somebody over here where I said, over here in Summerdale. But you cannot come to my house or
Okay, ma'am. When I come to your location, I just need to know what's going on. Was somebody shot recently?
Yes, about 5 police say where I go.
Okay. What's the location?
It's over here on Cleveland Avenue.
Cleveland Avenue. What else, ma'am? I need numbers or 2 Cross Street?
Old Hateville.
Old Hateville in Cleveland Avenue?
Yes. I don't want to talk loud 'cause I don't want to get myself in no trouble.
That's fine. Okay. You said okay, the mail is inside of what home?
My friend's apartment. She panicking. She don't know what to do.
Okay, that's fine. Okay.
But she got her mom and her baby now.
Okay. All right. And what's the
number? We stay in the new townhouses in Summerdale. And she stay in building C, but I'm not for sure what the apartment number is. But she stay in building C. When you come around, you come through the gate.
Okay, so who was shot?
I have no idea, babe. I promise I can't tell y'all that. I don't know. All that I know, she came to my house and told me that the guy that shot somebody named Young Thug, or whatever it's supposed to be, shot somebody, and then the guy is in her house. So I don't know how y'all can do that. I'm trying to get her out the house, but she wants the phone now.
Okay, all right. Okay, so you're saying the female won't answer the phone?
I did try to call her phone.
Now, the reason I thought it was important to let y'all listen to the tape first, because I want y'all to hear the argument and how the defense and the prosecution explained the series of events or what they thought was heard on this tape. Because I'm going to be honest, y'all, I don't understand how this is even being read in court. You understand? Now, I didn't go through the whole process today. One of y'all probably can tell me, was this let in as evidence or not, or could it just been played in court? But I did read up and watch enough to see that there was officers that testified to the sequence of events that led up to this tape. So I'm assuming that it was let in court. You understand? But I want y'all to listen to Brian Steele and the prosecution, along with the judge, go back and forth about the admissibility of this tape.
They are not being called as witnesses at our trial. So therefore, it starts out with, this is inadmissible. It's just inadmissible on confrontation clause, unless the court finds that this call is not testimonial. If it's not testimonial, then under Crawford versus Washington, the highest court in our country said, well, then that doesn't implicate the confrontation clause, because the confrontation clause is some utterance being made for the purpose of an arrest, a prosecution, of possible evidence in a trial. So if it's used for that purpose, so that's a primary purpose, doesn't have to be the sole purpose, but the primary purpose, then the evidence cannot come in because these witnesses are not here. If the primary purpose, however, is to stop an ongoing situation, so the victim in the Pitts case, she is married to Mr. Pitts. She is being beaten. She is calling 911. The 911 call is being hung up. She is getting back with 911. Eventually, it doesn't go through. The call, the police come out because they have the address. The police find her in a shambles. The place is a mess. They arrest Mr. Pitts. Comes time to trial, Ms. Pitts says, which is valid, under the marital privilege, I'm not testifying against my husband. So she's unavailable. She's not there. So what the trial court did is say, I'm letting in the 911 call because I find that the victim, Ms. Pitts, was observing, seeing, because you have to do both, confrontation clause and hearsay, this situation, and she was not calling to have Mr. Pitts arrested for something. She was calling to save her life. It was what they call an ongoing emergency situation. And because of that, the primary purpose, according to the trial court, and then, of course, it's affirmed by the Honorable Supreme Court of Georgia, they said this is close, but they said we're going to affirm the trial court. They said that because the victim made the call, because the victim was in the throes of an ongoing emergency situation, she needed help. It was not something to just make an arrest. Our case, I think, stops right away with the first words uttered by the caller, because it's the caller now. It's the caller calling for an emergency situation. And the caller's first words when the 911 operator said, you know, what's your emergency? The caller immediately said, it's, and then there's 3 dots. It's not an emergency on Mr. Williams' motion, Mr. Williams' Exhibit A, as in Alpha Elisa. Then the next information gets all involved, and it's a short call, but it's a lot of information. The caller does not really know what's going on. The caller says immediately after that this is not emergency, she states the guy that shot the guy over here off Cleveland Avenue, he's in my friend's apartment, and she's panicking. She don't know what to do. 911 operator says, what's going on? The unknown caller says, the guy, I guess, she's speculating. Somebody must have shot somebody over here where I stay at over in Summerdale, but you cannot come to my house or through my house. So what she is saying is she is repeating information that she doesn't know if anyone got shot, but she guesses that, assuming that, and we really don't know the basis. Maybe she knows it because she was told it by the neighbor. Maybe she knows it because she heard it on the news. Maybe she really never knew it at all, but saw police officers in her apartment complex. So this is something where we ask this honorable court to analyze, is this really an emergency? And the reason I say that is because the caller is also not panicked by saying, you got to get here now, you got to get here now. The caller is constantly saying, I don't want my name to be used. I don't want my children's name to be used. You don't have my address, don't have my telephone number. You can't have my name because I don't want retribution. That is the key to this is going to be an arrest. Person is going to find out who's arrested that I made the call and I don't want to be involved. That is totally for purposes of arrest and prosecution, which does trigger testimonial evidence. And if it's testimonial evidence, Mr. Williams gets to confront the person. The unknown caller says that, Your Honor, 1, 2, 3, 4, 5, 6 lines up from the bottom of Mr. Williams A. The caller says, yes, I don't want to talk loud because I don't want to get myself in no trouble. So she's not saying you got to get here, you got to get here, you got to get here now. She has the wherewithal to say, I don't want to be involved. After that, on page 2 of Mr. Williams A for today, the operator asks at the very top, where the operator is speaking for the first time, okay, so who was shot? And the unknown caller says, I have no idea, baby. I promise you, I can't tell you all that I don't know. And then she goes through, the only thing I know is that my neighbor, she, but I'm assuming the neighbor, came running. She came to my house, told me the guy that shot somebody named Young Thug, or whoever that's supposed to be, shot somebody, and the guy is in her house. So I don't know, y'all can do that. I'm trying to get her out of the house, but she won't answer the phone. So I asked the court to understand and consider this. When I went through this, I realized that the neighbor then was in the house, according to the caller, but then left the house. So somehow the neighbor's not trapped in the house. The neighbor then returns to her own house. That's what's going on here in this 911 call. So clearly, this is not a emergency where the neighbor comes over to the caller's house and says, call the police. My child and my mother are there, and there's a person in there that's threatening us. I need to run. I need to go back in and help my mother and my daughter because there's an ongoing emergency situation. That didn't happen because we know that the neighbor, according to this caller, if any of it's true, the neighbor comes over, somehow freely leaves her apartment. She doesn't say she escaped from the apartment. She doesn't say that she was being beaten in the apartment. She doesn't say anything. And she uses this term to then say she went back. In addition to that, Your Honor, after the neighbor leaves the apartment of the caller does not call 911 immediately because the caller is telling the 911 operator later on, it says, my neighbor will not answer the phone. But then on page 2 of Mr. Williams A, five callers up from the bottom, it says unknown female. That's them calling now. Meaning that the neighbor went back to her home or went wherever she went, and she made a phone call to the caller, unknown caller calling 911. That means that all of this is that this is a mishmash. In addition to that, the only place in here that names what I'm going to say, I'm going to adopt Jeffrey Williams, young thug. Where did that information come from? It can be presumed that it came from the unknown neighbor, but did it come from someone else? Because it says that shot somebody named Young Thug or whoever that's supposed to be. So was Young Thug shot? Did Young Thug do a shooting? I don't know, but when it says somebody named Young Thug or whoever that's supposed to be, without this caller here asking her questions, pointed questions, saying, where did you get that information from? It is a violation of Constitution Clause rights. And Pitt says that if you find some statements testimonial, some statements non-testimonial, you redact the statements that are testimonial. Where Young Thug, whether he was shot, it says that shot somebody named Young Thug, whether Mr. Young Thug, Jeffrey Williams, was shot or not, or did the shooting. The bottom line is that doesn't go to the emergency. That information comes from somewhere that we have the right to cross-examine. So that would have to be, at the minimum, redacted, respectfully. I think the whole thing is testimonial, though. At the end of it, Your Honor, the two-line, in page 3 of Mr. Williams' Exhibit A, as in Elisa Alpha, if you go up to the first time that the caller is speaking on that page, it says unknown female. All right, please don't tell anyone I made this call. That does away with all of the belief that when you're in a panic and you're calling for help, you don't think about things like, don't tell them I called.
Brought up as being the most illustrative of the point that he seeks to most emphasize to this court, that somehow the 911 call is inadmissible because it violates the confrontation clause, and that's Pitts versus the state. On page 3 of 4 of the copy of Pitts given to the state and to the court, I believe by Mr. Williams, the court does an analysis, and specifically in paragraph, the first paragraph on page 3 of 4, it notes that coming from page 2, that the caller in Powers called to report a defendant for a recent parole violation. And the court noted in Pitts that the caller made the report made the call to report a completed violation of law, and would be very opposite of what she ever intended to happen, because her sole purpose was to gain aid and assistance for that baby, that mama, and that neighbor that came to her saying, in a panic, Young Thug's in my house. So our first argument, Your Honor, is that this is not a confrontation clause issue by any means. Just to give the court a little bit of background, on this date, September 11, 2013, officers had gone to this apartment for a reason altogether unrelated to any shooting or anything like that. When they got out there, they heard gunshots, and they saw Walter Murphy, who we later learned was Walter Murphy, shooting at a man named Derek Dotson. The officers turned and went to pursue Walter Murphy, and when they did, he jumped into a red Nissan. And they noted that there were 4 individuals in the Nissan. The Nissan comes, speeds off, crashes over a wall, and crashes into a brick wall. 4 people get out running. The CAD report relays exactly the sequence of events. We will be entering into evidence 911 calls, the first 911 call that got the officers out there, and then the court will be able to hear the sequence of events. And around the time that this person made this call, just before, the court will hear officers saying, one just went under the car, the other one went a different way, and they're describing the places that each one of them went. So in the midst of all of the commotion that is going on and being relayed over radio traffic, as a matter of fact, we have 2 different numbers, 2 different case numbers that are associated with this particular case. One ends in 1038, one ends in 1308. They get another call that they don't even realize is related to the call involving the shots fired. And that other call is the 911 call that the court heard today. And when they reached out over the radio and said, we got this caller who's calling in about this guy, the shooting at Summerdale, Young Thug, they then learned that it's related to the first series of calls. And that's how they all got put together in the first place. So it doesn't happen in a vacuum. It doesn't happen after any prolonged or any period of time whatsoever. It's actually a series of very fast-paced events that take place. So the car goes over the retaining wall, the 4 occupants get out and run, the police are telling each other over the radio where the occupants are going, and in the midst of all of this, the police get a call from a woman, frantic, not wanting to be identified, describing her neighbor having come to her in a panic just a moment ago, and now she's not answering her call. For all she knows, that neighbor is in there dead. The reason that she is saying what she is saying about the shots and the police, she's not even able to get it out in a very cohesive way. She's saying, I don't know, just come now. Her whole purpose for calling was to get the police to respond to what she perceived as immediate danger. So the idea, though it was kind of glossed over, that this is testimonial, is belied by the contents of the call and the circumstances surrounding the call and the information relayed during the call. So before I leave the fact that it's not testimonial and that it's made solely to get the police there to respond to what this caller perceives as a circumstance involving immediate danger, with the court's permission, I'll pause and ask the court if the court has any questions that I may answer for the court regarding the confrontation clause, because I don't want to conflate the issues.
How can you tell that it's not, who the unknown female is talking about? I assume that you're not bringing the unknown female or the neighbor in. Is that correct?
So, Your Honor, that is correct. And that would go to the issue of hearsay that I'll address in a moment, apart from the confrontation issue. And I do want to point out, in Michigan versus Bryant, our highest court notes that an assessment of whether an emergency that threatens the police and public is ongoing cannot narrowly focus on whether the threat solely to the first victim has been neutralized, because the threat to the first responder and public may continue. So when the court is asking whether we're going to bring them in or not, I, with the court's permission, will speak to those matters.
Well, I don't get to that until I determine whether or not it's a confrontation
Yes,
or
Your
it's
Honor.
testimonial. But the issue is, she starts out by saying it's not an emergency. Okay, and I'm looking at this because I'm being asked to exclude comments that or statements related to this particular 911 call. Ordinarily, 911 calls have to be looked at on a case-by-case basis, and I think that Pitts and Spratlin and Grimes all kind of indicate that. So I got to look at that, but I also am looking at the fact that her statement is, I have no idea, baby. I promise you, I can tell you all. I don't know. The only thing I know is she came running. She came to my house. She told me that the guy that shot someone named Young Thug or whoever that's supposed to be shot someone, and that guy is in her house. So we don't really have, I mean, there's no granularity. I agree with Mr. Steele about what is actually going on. I could parse out several hypotheticals of what she calls or claims may have happened. And it's unlike Pitts and the other cases where you've got somebody who's making that call. You're basically, it's already in a third party situation, because she's relating kind of what she thinks is going on. Now, so that's kind of what I have to kind of decide to begin with. Is the call primary purpose testimonial for the purposes of prosecution or gathering information for later? I can see how it could be either one, but I have to kind of take a look at the facts and circumstances to make a determination as to that. So, but unlike Pitts, the victim is making those calls.
So, Judge.
So in this case, you got a third party who really doesn't we don't have granularity of what she's talking about. I mean, and so I have some problems with that to begin with.
So I would like to separate out and point out that the content of the call, the fact that there is a matter that she is trying to get the police there to address, and the credibility of the content of the call is a matter, again, that I believe belongs within, is it hearsay and is there an exception? Before we get to what she is saying as it relates to whether or not this is trustworthy, and I believe with respect that is what the crux of that particular issue that the court just pointed out, is it trustworthy? This is a third person making a call about something she just experienced. So is what she is saying trustworthy?
I'll give you that much, but okay.
And so for the purposes of that, Your Honor, I believe that will fall after the court makes that determination as to the confrontation clause. And as in Davis versus Washington, Your Honor, 547 U.S. 813 at 822, the United States Supreme Court distinguished, of course, testimonial and non-testimonial statements, saying that non-testimonial statements, when made during a police interrogation under circumstances that objectively indicate the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. And that is exactly what, even if she says it's like, it's not an emergency, don't make a big deal out of this, come get this person out of my neighbor's house. Essentially, that's what she's saying. I don't want to call the reason she says, and it is apparent from the call, objectively listening to it, the reason she says it's not an emergency, even though her voice is panicked, is that
I don't think her voice is panicked. She's kind of just talking. I mean, she's talking in low tones. I don't, at least from the court's perspective, I'll disagree with you. I don't think
Yes, Your Honor.
I don't think it's an emergency.
Yeah.
I mean, she herself says it's not an emergency. Like I said, I got to look at the primary purpose for the call. Is the primary purpose for the 911 call to provide information that may be used later, or is it for an emergency or some other reason? Pitts kind of distinguishes that because you got somebody who's getting their, for lack of a better word, their behind torn up, and she's calling, and there's certainly where it could be argued that truly is an emergency. In this particular circumstance, it seems like she's relating information because that's the first thing out of her mouth. I can't discount that. The first thing out of her mouth, she says, not an emergency. Because 911, what's your emergency? And she's not saying, hey, my neighbor is getting blah, 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 or that I heard this and this, and I've seen this, and that's kind of where we are. Where she's relating a third party. I mean, and that's kind of that's the issue of whether or not I got to struggle is whether or not it's testimony or for the purpose of primary purpose. Okay. I could see how I understand the state's argument. I understand the defense argument, but that's what I got to kind of wrestle with to begin with. And then I'll decide whether or not it falls under any of the exceptions to the hearsay rule. I agree with Mr. Steele. You didn't give notice under the residual hearsay, so I'm not going to consider it under that.
Your Honor, and Mr. Steele did point out the very last argument that we made and sort of went past the first two. But going back,
you need to focus on whether it's testimonial, because if I don't find it's testimonial, I don't have to go to the other second prong. First step is if it's testimonial, it ends there. If I find that it's not testimonial, then I'll move to whether or not it falls within a hearsay exception. But I'm not convinced it's not testimonial yet.
Yeah. I'd ask the court to look at Varner versus the state, 306 Georgia 726, Your Honor. And in Varner, the court states...
What was the citation?
306 Georgia 726, specifically at Penn site 731, Your Honor. And it's on page 6 of 10 of the copy that I believe was provided to the court by Defendant Williams of Varner.
I don't think I have Varner.
Okay.
Oh, wait. Before I start telling you that. No, I don't have Varner.
Okay. It's at Penn site 731, and that was again 306 Georgia. Her mama and her child, and she's not answering. And it's all happening in a matter of moments. And that's apparent because of the way that the calls come through and the radio traffic comes to her for help. She's not trying to establish anything. Of course, the courts put a pin in the Confrontation Clause issue, but she's not even trying to 911 operator what excited utterances she just heard and she didn't pick up. I just tried to call her. She cannot make it any more apparent that this is something that she is perceiving right in that moment. She dialed 911 because she can't get the panicking friend who is in her apartment with the man that shot somebody and her baby and her mama, while police everywhere out here. And I'm going to talk low so can't nobody hear me so I don't get in trouble. And don't tell him that you even got this call, because I don't want him to come and retaliate against me. And I got kids that he might harm. She can't make it any more apparent that this is something that she is experiencing and that her friend is experiencing as she is talking to the 911 operator. Additionally, Your Honor, I would argue that the caller, the 911 caller, under 24-8032 is making an excited utterance. Because even if she is not sounding panicked to the court, her hushed voice, she is sounding out of breath at times. She is saying, expressing urgency through her words.
One snippet. So is there going to be more?
There are. Sense impression, 24-8031, and the excited utterance, 24-8032, exceptions to the hearsay rule. And Your Honor, the excited utterance exception looks at, as with the present sense exception, it is not necessary that the statements be made contemporaneously with the startling event or condition. In other words, the panicking person doesn't have to be standing there panicking while she's making the call, relaying the information. She was startled by her neighbor coming to her, telling her this information. Her neighbor is startled by somebody coming in her house that doesn't belong there, that was just involved in a shooting.
Is there going to be other evidence through testimony, witnesses, and or other related 911 calls for this incident?
Your Honor, there's going to be other evidence that Jeffrey Williams was involved in this shootout in the shooting and the.
I'm talking about this particular incident on September the 11th of 2013. Meaning, because to your point, is there going to be some other evidence or some other testimony saying, hey, we were called to a blank incident about at this location. There are multiple 911 calls, or there are witnesses to testimony to bring that out, because you're telling me it was an emergency. So if there's other surrounding circumstances, as you said, I'm supposed to take a look at it in context and not a vacuum, then that might be an issue I need to kind of consider, because I'm only hearing one snippet. So is there going to be more context evidence to this particular issue? So what is that context you're going to present?
A few things. As I said, regarding the 4 people who jumped out of the car, there's going to be an officer's testimony that she was chasing them in a particular direction, that one went in one direction and another went in the opposite direction. And when she went to chase them over the wall that she was chasing them over, she was called back and she had to put her attention on Frederick Prothro, which was a person who was shot during this incident. There will be testimony, I expect, from a witness who will say that while they were running from the police, that shots were fired inside the car, that Young Thug, or Jeffrey Williams, actually had a gun, that he, Walter Murphy, and Frederick Prothro had a gun, and that Jeffrey Williams or Walter Murphy was probably the person that actually fired the projectile that hit Frederick Prothro, because while they were fleeing from the police, 3 shots went off inside the car. There will be testimony that when they fled the police, that defendant Williams ran in a particular direction, which we believe will be in the vicinity of the description that this caller gave for her friend's apartment. There will be testimony that's it. That's the general. And then, of course, as I stated earlier, the 911 custodian of records, in explaining to me, because I had the question, how did we get from 1038 to 1308? Was there a mix-up? And she specifically said no. When that call came in, when the 911 dispatcher sent it out, when they called it out, they were then told that call is related to the 1038 call. That is a part of this call up here. So that's how they even end up. They're on one CAD report that I have, and were it not marked up, I would show the court that particular CAD report. And we do intend to introduce as evidence that CAD report that has that these are 2 related events. And in fact, the remaining reports that lead investigator Velasquez uses in the entirety of this investigation has that 911 call number attached to it. It's the entire case file is ending in 1308. So in fact, this particular case, the way that it even looks in all of the discovery given to everyone in this case, The case file case number ends in 1308, which is started and initiated by this call right here.
In the totality of the circumstances, it could be deemed as an emergency. So how would you respond to that? They pointed out these different statements, and also in the totality of what was going on at that point in time, why wouldn't this be an emergency situation?
The state's recitation of facts are not accepted.
Well, I'm just looking at the transcript you gave me, in addition to what the state's proffer is. So I think some of the statements in here.
So I'm not conceding that it's an ongoing emergency because I'm taking the caller for what she said.
All right. Give me a few minutes, folks.
Okay.
All right.
Thank you, sir.
We're going to be in recess.
Do implement reports and all that stuff, but not directly directed to records.
Okay. But based on what you're saying. Film, no film, that you all have come up with an agreement with those parties who have filed Rule 22s?
Yes, Your Honor. Those that are highlighted are individuals that either are former law enforcement and now are civilians that would.
Now, I know y'all was a little lengthy, and I tried to shift through it just a little bit, but it was a lot of importance in that back and forth that went on for probably 30 minutes. Because you got on one end, the prosecution saying, look, we want to bring this evidence into court, but we don't want the people to testify against it. You know, we don't have actually the people that's going to come in court and say, look, this is me on the phone, this is the girl that called the police, and this is the victim. We don't have none of that. And then you got Brian Steele saying that, well, if you don't have none of that, then this evidence shouldn't be allowed in court because everybody got a right to face their accuser. And in this situation, you got somebody actively admitting that Young Thug, through third party, shot somebody. But they don't even know who the person is. And on this channel, I spoke about hearsay and third party evidence and how state courts don't allow it. But I also told y'all they got loopholes. And whenever it's convenient, they always seem to find a loophole to allow this thing to happen. Now let me tell y'all what happened and how this all played out. What it sounded like is somebody was shot. The same Young Thug was involved in the first shooting, because it was two. And during the police pursuit, 4 people was in the car. Gunshot went off, so more than likely, the reason they can't get this person to come in, if this person even exists, is that they was friends of Young Thug. They all dispersed, went different ways, and this person ended up shot. Now, when this phone call happened, you know, when the conversation happened between the lady on the phone and the person who contacted the woman, you know, her neighbor, she might have inadvertently let out that Young Thug shot him. But you can make an argument in these type of situations. You talking about high intensity, police chase, 4 people in the car, probably multiple guns, that you don't know who shot him. So that person, if he did say it, because we don't even know, because he's not even going to testify to it. If the person did say that Young Thug is shot that person, that don't actually mean that they did it. They could just be assuming. And how is this even to be allowed in court where he can't even face the people that's saying that this happened? Like, yo, this is a travesty of justice, and I'm going to keep it honest with y'all. I'm kind of glad that people can see this. Now, it's messed up that it's happening to Young Thug, but this is what happens to people every day in this court system. And it's starting to seem like, at least in Young Thug case, that it don't matter how much money you got. If the system wants you, they're going to railroad you. They're going to run over top of you. Now, you do got the Supreme Court. You got the appeals courts that normally come in down the line sometime and, you know, reverse these convictions, because it looked like to me the fix is in. The fix is in. No matter what the prosecution bring to evidence, the judge allows it, you know. And this don't seem like this was a situation where the defense was even aware of this tape. You know, it looked like they just brought that in today and you know, put it to the judge, and they talked about it in today's proceeding and decided to make it evidence show. But that's not how the system is supposed to work. But this is how it does work in reality. And you wonder why so many people going to prison, black males in particular, going to prison, because the system gets people and does this to them. Whatever they want. Whatever they want. But I don't know how y'all feel about this in the comments. Maybe I'm biased. Maybe I just don't like what's going on, yo, because I know how the system working. And it look like to me it's working just how they wanted it to work. Just not working for Thug. Judge Glanville, Ysl Glanville, then allowed every type of evidence that the prosecution can actually got their hands on to be presented during this trial. Meanwhile, not doing nothing for the defense. Not doing nothing for them. I'm pretty sure Brian Steele was upset. But let me know how y'all feel about this in the comments. Another day of Keep It G News.
Nigga can't do what I do, y'all niggas can't copy me. Let's keep shit G. Let's keep shit G. Let's keep the shit G. Let's keep shit G. Let's keep shit G.